Can an employer prevent an employee from working with a competing company? That is the topic for our discussion today. Generally, what happens is that when an employee joins a company, the company invests in the employee by giving him some form of training. They go through a period of training where the employee is taught a few special skills. For example, in the software industry, if depending on whatever is the latest update or whatever software language is in vogue, employers make the employee undergo a specific training program. And after the training program, let's say the employer says, okay, Ramana, you have received training from me, therefore you cannot work with a competing company. Is that legal? Is that legally acceptable in India? So I want you to just to simplify this, take an example. Let's say, for example, I, Ramana Reddy, join a company in 2022 and my employment term is for 5 years. So from 2022 to 2027. Now, the legal position in India is that during this period, during the 5-year period, I cannot work with a competitor. Because the thinking is that, look, you are drawing a salary from the company, and it is therefore your job, it is your duty to work for the welfare of the company only, and not work for some other business. And you need to put in all your efforts or your best efforts to growing the company. This is for the 5-year period. Let's say after the 5-year period has expired, in that scenario, let us say, for example, let me make it worse. Let's say that I have signed the employment agreement, and the employment agreement says that Ramana Reddy, after 5 years, you cannot work with a competing business. Even in that scenario, courts in India have held that that is not legal. That if there is an employment contract that prevents Ramana from working with another company after the 5-year term, then even then, that is not legal. No court in India will uphold that kind of a clause in an employment contract. This is based on several policy considerations. But before we get there is one small exception, which is, let's say that I worked on a deal for the company, and I know specifically how much money was paid to that company under that deal. And there is some confidential information that is in my possession that only I am aware of, or I am within the inner circle of the company and I am aware of that. And I join a competing company. In that kind of a scenario, to that limited extent of those confidential information that is in my knowledge, that confidential information, courts will uphold. Courts will say, look, if you have learned something on the job, if you have learned Java or C++ or whatever, I have no idea as a lawyer, but whatever skills that you have learned, that is for you. But if you are in possession of confidential information, even after the 5-year term, even after the expiry of your employment contract, you cannot go and disclose confidential information to your competitor and put your old company at a disadvantage. Now, this legal position is tempered by policy considerations. So one is that, generally speaking, when an employee applies for the job, he wants the job, and there is unequal bargaining power between the employer and the employee. The employer has more bargaining power, the employee has lesser bargaining power, and therefore, even if the employee signs an agreement saying, I will not work for a competing company after the 5-year term, courts will refuse to uphold it. Now, just going by bargaining power, now I want you to consider a different scenario. Say, for example, let's say that my company buys Haldiram's as a company, right? They make mixtures, moong dal, whatever. If after buying the company, Haldiram goes out and starts a competing company and puts me at loss because I have bought the goodwill of the company. I bought the same business. Now, using their expert information, they go start a competing company. courts say that that is not legal because that is goodwill, and you cannot go start a competing company. And moreover, if you think about it in terms of bargaining power, whether we agree with the theory or not, but if you think about it in the terms of bargaining power, a company to company generally, they're free to do the deal or not do the deal. That applies to employees also, but anyway, but the thinking is employees have lesser bargaining power. So let's say that I am free, or Haldiram's is free to sell the business to me, or not free to sell the business to me. And after selling the business to me, they are not free to go start a competing business. Or let's say, for example, that I am Subway. I have franchises all across the country, and one of the conditions in the franchise agreement is that if you take a Subway franchise, you should not go and start a competing franchise with Subway. In that scenario, again, most likely the court will uphold those things because these are B2B, these are business to business kind of contracts, and therefore, this whole bargaining power thinking, that's hard to be in these situations. So just to summarize, as far as the employees are concerned, let's just to simplify again, let's just take the example. If you enter into an employment contract for 5 years, and during the 5-year period, you cannot work for a competing company. After the expiry of the 5 years, you can work for the competing company, provided you don't leak confidential information which belonged to the old company. I hope that was helpful. Thank you for watching.